Back in business, so let's make sure that we're alive and well on all the different platforms today. And it looks like we're almost there. And it looks like, okay, now we are live. So let's get rocking and rolling. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and I to follow, but sometimes have a little bit of difficulty doing so themselves. And so that's why we started this show called Watching the Watchers, so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency back down upon our very system with the hope of encouraging some meaningful change. And we're grateful that you are here and with us today. We're back in business. Yesterday, we did not do a live stream because we were over at Viva and Barnes. We were hanging out with those two gentlemen. I thought it was a good conversation, had a lot of fun, learned some things, and I think it was a very relevant discussion for a lot of the stuff that's going on in the country today. Largely, we talked about the Derek Chauvin trial. So if you did not were able to catch that, I'd encourage you to go take a look at that at Viva. Frey is the name of that channel. Go look up Viva, V-I-V-A. Frei. Go check out his channel. A lot of great content. We had a very nice discussion, so I want to make sure that you don't miss that. Today, we're getting into a lot of different things. Specifically, we're going to spend some time getting caught up on the Derek Chauvin trial. Interesting last couple days. I've been posting some clips here and there on Twitter and over on Locals. And yesterday, Judge Cahill got a little bit agitated with the media. I want to bring you up to speed on what happened there. But we lost a couple jurors, and now we're back up to 12 jurors. So today, they seated 3 new people, and Judge Cahill this afternoon left the bench, did a little bit of a mic drop, said, "Oh, I'm out." Just kind of laced into the prosecutor and then just stormed off the bench. So I want to show you what happened there. Very interesting. And I think it was well deserved. And I want to break down what went on. So we're going to take a look at some of the new jurors. We're going to go through some of the issues that are still outstanding. Judge Cahill is going to rule on a bunch of stuff tomorrow. And so we got to bring up, get caught up because we were not here yesterday. Are going to do that today. Then we're going to change gears. We're going to talk about this judge, Brett Bloome. I don't know, but that's his last name. And he has been arrested on some serious charges. Want to show you a little bit about what's going on there. This is a judge, somebody who used to preside over children's cases, and he is caught in a mess right now. So I want to show you what that looks like. Kind of a gruesome case, a little bit of a content warning on that maybe, just because it involves children, crimes against children, some of the more gruesome stuff that happens out there in the world. Want to detail that. Of course, he's a judge. He's somebody in a position of power, and we want to make sure that he gets accountable, just like we hold the police accountable, prosecutors, politicians, and judges. So Judge Bloome, we're going to call it Bloome, is in hot water right now. We're going to detail what is going on there. Then we're going to take a look at the Capitol Hill cases. Specifically, we're going to talk about Jacob Chansley. There are a lot of these Capitol Hill riot cases that are still moving through the justice system right now, and we're going to spend some time talking about them. In particular, I want to focus on kind of the one that everybody is up in arms about. Jacob Chansley is sort of the caricature of this entire riot, and so we're going to kind of focus on his case a little bit. U.S. attorneys just yesterday filed what's called a motion to continue. They want to extend the trial. Remember, he's being held in custody. They want to extend the trial without letting him out of custody, and they don't want that to count against their speedy trial requirements. I think I read that right. I think that's what we're going to talk about. We'll dive into that more. We've got the motion from the U.S. Attorney's Office, and are going to go through it at the end of the show. Before we get into the material, couple quick reminders. If you want a copy of the slides that we're about to go through, those are over on our platform called Locals, locals.com. Watchingthewatchers.locals.com is where you can head on over to get a copy of the slides, get a copy of my book, and if you have questions that you would like to ask about what we're talking about today, that's the place to do it. There's a live chat over there. Mr. Ma, Miss Faith are going and moderating that, and they're clipping questions for me to review. So if you want to ask a question, the address is watchingthewatchers.locals.com. You got to support the show, but you get a lot of great stuff. And in particular, you get to meet and mingle with a lot of very cool people over on that platform. So go check it out, watchingthewatchers.locals.com. All right. So as I mentioned, let's get into the news. Chauvin, day 9 is today. Yesterday was day 8. We got to get caught up on both of these things. Yesterday was a little bit of a fiery morning. Judge Cahill started the session by ripping into the media. Apparently, the media has literally been zooming in on the attorney's notes to try to gain information about what their next move might be. Totally inappropriate. I mean, beyond inappropriate. Judge Cahill, not happy about it. Also, the media, now I didn't see this out there, but apparently this is happening around Minneapolis, around Minnesota. They're sort of detailing the security infrastructure, what is going on in the court building as it relates to security. Where are people going? What do they have to do? Where are they parking? Where are they walking from? And so you could see how this could be so problematic for jurors who are already in the middle of, I would say, the nation's most high-profile criminal case that we've had, I don't know, since OJ maybe? I mean, maybe Cosby's up there, but this is a very, very high profile case. It captured the entire country. And so if you are a juror and you are concerned about your safety, the media exposing the security parameters is problematic, and the judge laces into the media at the start of the proceeding yesterday. So I'm going to show you that clip. Then yesterday, the judge, as a refresher, so much has been going on in this case. It's sort of hard to digest it all into just one little segment here, but we're going to try. And yesterday, the judge was also responding to the settlement. Remember, there was a $27 million settlement that the city council paid out to George Floyd and his family right in the middle of voir dire, which is jury selection. It's a very unusual time to do that. Something sort of seems awry with the timing, almost feels intentional, like they wanted to signal that they were leaning one way and they wanted to influence or impact the trial one way. That's just my opinion on it, but it certainly seemed provocative at the least and intentionally, I would say, problematic, let's say, at the worst, intentionally trying to manipulate the outcome of the trial. And so the judge, because this happened in the middle of jury selection, 7 jurors were already seated, and then this news of the settlement broke after they had been impaneled. And so the judge has now had to recall all of the 7 jurors and ask them what they knew about the settlement, if they had seen it. And remember, these people live there. They live in this vicinity. This is national news for me here in Arizona, probably national news for you. Even in other parts of the world, people are focused on this case. Many, many people from other parts of the world are focused. So if you are living there in Minnesota, you would imagine that even if a judge told you, hey, don't look at the news, don't try to find anything out about George Floyd, don't look into this, you are sort of halfway sequestered. We're asking you to stay off the news. But if it's on the radio, if it is on the headline, if it's the front page of every single newspaper, even if you get on Facebook, you're going to see some information about it. You're going to see a headline. Dang it. I know I wasn't supposed to see that, but you did. And now that you've seen that there was a $27 million unanimous settlement, the biggest settlement in the history of this state, then how does that impact you? Does that make you impartial? Does that make you more biased, less biased? What does that do? And so the judge, unfortunately, had to excuse 2 jurors who inadvertently saw the headline. And so I'm going to show you those 2. So from yesterday, we've got a couple clips, one of Judge Cahill ripping into the media, and then 2 of the jurors who have been excused. Then we're going to talk about what happened today. 3 new jurors made it onto the panel, and then Judge Cahill dropped the mic as he was sort of blasting the prosecutor for kind of complaining a little bit about how the defense was working their case. So let's get into it. I've been talking enough. Here is Judge Cahill yesterday at the start of the morning going into the media pretty hard.
Now, it's been brought to the court's attention that the media it's been brought to the court's attention that the media has been reporting specific details, trying to look at counsel's the documents, computers, posted notes on counsel tables. It's absolutely inappropriate. Any media who are present in this room will refrain from even attempting to look at what is on counsel table, either for the state or for the defense. Secondly, it has come to our attention that the media is reporting in detail the security arrangements on the 18th floor and other places. I find that completely irresponsible that that would be reported in the media. If that continues, the media is going to be excluded, and we're going to shut down the media center. So I hope everyone takes this to heart, that I consider this security issue very serious. And to report it out to the general public what our arrangements are is extremely irresponsible. And it will be met with sanctions if it continues. And I would hope that any media that posted such things online will immediately take them down. Failure to do so will result possibly in you being kicked out of the media center as well.
All right, so not happy about that. And it's good to see that from this judge. You know, this judge is pretty much unflappable, as we have been seeing thus far. He's been, thrown a lot of arguments from both sides, from the defense, from the prosecution. He's had some unruly jurors. He's dealing with a city council that's out of control. And he's been pretty level-headed until yesterday, and then again until today. He's getting agitated. He's getting irritated. And so people who, let's say, are not in the legal world, people who do not work in courts, might look at that, watch that clip, and go, oh, that's it? I mean, that's a tongue lashing? Like, that wasn't anything. Why didn't he arrest them and hold them in contempt of court? Well, what he's doing is he's giving them a warning. If it happens again, there's going to be sanctions, and there may be some additional penalties that flow from the gavel of this judge. But when you see a judge like this, I've been in front of enough of them that when you see somebody who's just super even-keeled, somebody who doesn't get ruffled, like this, just sort of going, all right, I'm going to turn this up from a level 5 to a level 6. That means they are very upset. They are not happy about this, nor should he be. I mean, it's absolutely ridiculous the media would be doing this. The media already, I've got a lot of issues with them, and just generally speaking, in general, in life of American politics and everything else, I think they're reprehensible in many ways. But they're specifically bad in this case. They are now trying to, I would say, sort of elevate the worst parts of this case to help craft the narrative, and the judge is getting pretty tired of it, as we saw right there. So Judge Cahill, we're getting a little bit more spunk out of him as the trial continues to devolve. And next up, we're going to take a look at how he was questioning one juror. So we've got two clips from jurors. This first person was excused, and I want to just show you what this looks like and why this is so important. And think about how frustrating this is from the court's perspective, right? They've already bent over backwards to accommodate and make this work. We've got COVID restrictions. We've got threats of riots. They've got barricades, barbed wire. Everything is on lockdown, dealing with all sorts of abnormalities that you wouldn't ordinarily see in a regular criminal case. So this judge is trying to get this thing working. He finally, he's gone through like 80 jurors, gets 7 of them seated. Then the city council, for some asinine reason, drops the settlement right in the middle of the proceedings. And so this judge is going, all right, so I got to call them all back and ask them about the settlement again. We just got them seated, and I already got to ask them again. And so this judge does it with just extreme patience. So the first clip, you just heard him get agitated, but then he just turns it right back down. He just turns the volume back down to level 5, and he goes and he starts asking these jurors questions, and he's very conservative. As soon as they start hinting that maybe they can't be fair and impartial because of the $27 million settlement, he's just patient. He goes, okay, well, we're going to go ahead and excuse you. Thanks for being here, and not even upset about it. Whereas, I'm not sure that my poker face would be that good. Let's look at this next clip here from Judge Cahill.
Late last week, there was extensive media coverage about developments in a civil lawsuit between the city of Minneapolis and the family of George Floyd. Were you exposed to any of this coverage, directly, indirectly, inadvertently?
Yes, I did see the headline.
Okay, and what do you recall of the substance of the headline?
I believe the headline was the city of Minneapolis agreed to pay out the family of George Floyd, I want to say, to the tune of in the $20 million range.
Okay. Other than seeing the headline, did you read the article or just kind of leave it at that, knowing it's probably related?
Exactly. I left it at that, saw the headline, and saw that dollar amount as well.
And what effect, if any, do you think this might have on your ability to be impartial? When we accepted you as a juror, did it move you one direction or the other?
I would say especially that dollar amount was kind of shocking to me. That kind of sent a message that the city of Minneapolis felt that something was wrong, and they wanted to make it right to the tune of that dollar amount. I think in the headline, if it would have said $2,000 versus $20 million, that's a big change. So I think that sticker price obviously shocked me and kind of swayed me a little bit, yes.
Okay, and so you think I think you left the courtroom, everyone satisfied you could be fair and impartial. Do you think that viewing that headline has maybe moved you, kind of now that you know that that's the city of Minneapolis' opinion? Not that we care about the city of Minneapolis' opinion, but if it has an effect on you, we appreciate the honest answer. Does it move you off the fair and impartial position?
Yeah, I don't really know the answer to that. I guess the trial still has the right to play out, right? It hasn't even started yet. So there are definitely a lot of facts to be heard through the trial. Again, I'm just trying to share with you what I know. My gut reaction to that, again, with the dollar amount being high.
Sure.
And I'm trying to leave that at that.
Okay. All right. Juror 20, I'm going to excuse you from the jury. We know that you did not seek out this information, but just on the possibility that you inadvertently saw it and it might affect your ability to be fair and impartial, we're going to exercise extreme caution here and excuse you from the jury. So thank you, though, for taking the time to come in. You are also excused from jury service completely. And so unless you get a summons in the future, you don't have to show up for our March 29th start date.
So very, very, very conservative. And I was a little bit surprised by that, actually. He didn't really say unequivocally that he could not be fair and impartial. He's kind of like, well, I saw it. I don't know. The trial hasn't started. What judge says, well, no, you saw it inadvertently and therefore you're gone. And that is pretty conservative, I would say. Just the fact that he saw it was sort of enough for him to be struck for cause. Whereas I think other judges might have said, well, okay, so you saw it. Can you set that aside and continue to be fair and impartial? Just like we saw in the original line of questioning. People would say, yeah, it was sort of the analog to the video. Many jurors saw George Floyd's video from the bystander on the side of the road. And we know that they saw it. They confirmed they saw it. They confirmed that they had an impact when they saw it, that this had led them to have certain opinions about what they think happened there. But the judge still said, okay, even though you saw it, can you set that aside? Can you continue to be fair and impartial? And many of the jurors said yes. So the judge could have done that again. He could have said, okay, so you did see the settlement, and knowing that that exists, can you continue to be fair and impartial? Can you continue to set that aside? And he didn't even go down that line of questioning. He just said, all right, well, you saw it. Can you still be fair and impartial? He kind of asked that preliminary question, and the guy said, well, I don't know, kind of waffled on it, but it wasn't an unequivocal no. It wasn't, I am certainly positive that I cannot be impartial anymore. Judge just said, well, that's kind of good enough, which is a very low standard to his credit. So he's got to go and pick another juror for that. And sometimes it'll take 10 to 20 jurors in order to get one. So he's making this trial go longer at his own expense in order to do the right thing. And so major kudos to Judge Cahill for that. Here's another clip of another juror who is also excused. And this is all from yesterday. Then we're going to change gears and talk about what happened today. Here's Cahill again.
A couple questions. Late last week, there was extensive media coverage about developments in a civil suit between the city of Minneapolis and the family of George Floyd. Were you inadvertently exposed to any coverage of this, directly, indirectly? Okay, you need to unmute. You can leave it unmuted, actually.
Okay. Yes, I was.
Okay, can you tell me what you heard?
Oh, about the settlement.
Okay, and do you remember any specifics about it?
I mean, the quantity was a large amount of money.
Okay. Do you remember a specific amount or just that it was a large amount?
20, over 20 maybe.
Okay. How do you think that would affect your ability to be impartial in this case?
Oh, it will impact it a lot.
It will impact you a lot? Tell me about that.
So last time I was asked about my strong opinions against Chauvin. Clearly the city of Minneapolis has some strong opinions as well. And this just kind of confirms my opinions that I already had.
Okay. It is a separate case. Different parties, different legal issues won't be part of the evidence in this case, but we understand and I'm sure you were inadvertently exposed. You didn't seek it out. We did accept you as a juror, but do you think now with this new information it would be hard to presume the defendant innocent, would hard to be impartial in this case?
I think it will be hard to be impartial.
All right. Then I'm going to excuse you from this case because of what was an unfortunate broadcast of certain details. And the fact that I appreciate you being honest, though, in saying that it would affect your partiality. So it's not a failure. You're telling us the truth. So we appreciate that. So you are released from jury service.
Yeah, so good on that young man for being honest about it. Judge, again, didn't push him hard on it. So can you be fair and impartial, or would this impact you? Yes, it would. Okay, that's it, right? We're not going to inquire any further. And the judge also didn't give any of the attorneys any ability to go and rehabilitate those witnesses. So, if this were the original round of questioning, then the defense would have been asking him questions about the settlement. The prosecutor would have been asking him questions about it, and they could have tried to sort of, rehabilitate him so that he could continue to claim that he would be fair and impartial. Whether that's, accurate or not based on human psychology, you can go into that debate in a whole different, a spin-off and debate that to the end of the ages. But here, they just kind of are exercising a lot of caution, and the judge just, okay, well, a little bit of equivocation there. You are off. You've been excused. And so this is what the panel and the board looks like. Let's call it a board. We've got now 12 of the 14 jurors selected. So we've got 2 additional people that we're going to try to squeeze in tomorrow. We are going to go through these 3 new additions today. There are a lot of prosecutors now who have been sworn in as pro hoc vice. Mr. Blackwell was a couple days ago. There is a new person who I have not seen in court yet, so we have not added them yet. But the judge, there was an order that there was yet another prosecutor who got sworn in pro hoc vice to come in and work on the case. And so we're going to see them at some point, or maybe see some of their work product. The way that this is sort of structured right now is there's a couple prosecutors who are coming into court and doing most of the argument, and the other prosecutors are out there filing briefs and doing some of the background research to support the attorneys who are in court. And so we don't know if this new attorney, this new prosecutor, is somebody who's going to be in front of the camera or in the backgrounds, but as soon as that changes, we'll update this. And you can notice that this is changing pretty heavily in favor of the government. We have a lot of prosecutors who are on board versus Eric Nelson, kind of him and his assistant. And the judge makes note of that today. So I wanted to just point that out, what that scoreboard looks like, or what that the board looks like. So as of Tuesday, this is what the jury panel looked like. And we're going to notice that a couple people got removed, as we just heard. So I think it was number 4. It was somebody who was white. I know that. So it's either number 4 or number 1. I do not think it was number 1 because he was juror number 2. And when he got called in for questioning about the settlement, he seemed to be like he didn't even know about it, or it wasn't an issue to him. So I think he stayed on the panel. And I think number 4 was the person who was eliminated, along with number 6. I know for sure that he's not on the panel anymore, and so they get struck through. And what I did is I moved all of the other jurors here up into their spots. So we're going to put number 5 at number 4, number 7 at number 6, and we're going to move 8 and 9 up. And so it's going to look like this. So now we're back to 7, and then that is with the 2 removed. And then yesterday we added numbers 8 and number 9. And so yesterday, the number 8 is a black male. He said no to defunding the police. And number 9 is a multiracial female who is in her 40s. She's a consultant, does some corporate consulting. She's married with a son, and she says that settlement does not equal guilt. So these were the 2 new people who were added yesterday. And then today we're adding 10, 11, and 12. And so let's flesh out who these people are. Number 1, we have, heading into Thursday's proceedings, 9 jurors had been selected to determine whether Chauvin caused the death of Floyd. The 10th juror, this person here, is a nurse. She lives in Edina, assured the court that she could judge the evidence fairly despite having seen portions of the video and hearing about the settlement. Attorneys for both sides focus strongly on her 27 years of nursing in light of the trial, likely touching on how police dealt with Floyd becoming unresponsive during his arrest and connection of drug use to his death. So she's a nurse, and we're going to see a lot of medical testimony in this trial. We're going to determine whether or not the drugs killed George Floyd, whether Chauvin's knee on the neck killed George Floyd, whether it was a combination of the 2 of it, whether they should have done something differently in order to save his life. And so she's a nurse. She's somebody with a lot of practical hands-on experience in this field. And so, of course, there's going to be a lot of questions about this. And I've detailed this before on the show. I think we talked about it on Clubhouse, may have talked about it when we were talking with Robert Barnes about whether we want certain individuals from certain professions on a jury. So this is a lot of the time why lawyers are not on juries, because people who are also on the jury might look to the lawyer for guidance, for answers. They'll say, oh, well, we don't know how to handle this thing that's in front of us. This is a big, tall order. We got to determine whether somebody's innocent or guilty. Oh my goodness, that's a lot of pressure here. Is there anybody here who knows how this works? Oh yeah, there's a lawyer. And so the danger there is that other jurors will sort of lean on the lawyer and they will have undue influence over the deliberations. Here, same issue. What if we're talking about a lot of, toxicology reports, cardiac arrests, pulmonary, this, that, and the other? Are the jurors going to go and lean on this nurse for answers? Well, it came up today. The woman, who is white, said her personal training would affect how she would look at the evidence. All right. Said, we all use our life experiences to make judgments, she said, which for her, duties include resuscitating patients in urgent situations and dispensing opiates while on the job. The judge interjected and pointed out that she can't be an expert witness in the jury room, and she agreed that would be wrong. So she cannot go and sort of claim special privileges when she's in there. Prosecutor Steve Schleicher quizzed the nurse about drug addiction, and so you can see this from this line of questioning. The prosecution is really going to be hitting up this addiction component. She said she has seen patients who are hooked on opiates, and she doesn't believe any particular segment of the population is more susceptible than another. It can be anybody, she said. And I would agree with her on that. That's my experience. Drugs are very indiscriminatory, especially the opiates and some of the more hard drugs. Kind of hits everybody across the board, which is just unfortunate. And so, as I mentioned, Prosecutor Steve Schleicher, they're really hitting this drug addiction thing. You know, they're going to say that George Floyd had the drugs in his system because he was an addict. He was addicted to fentanyl, and that's why the 11 nanograms per milliliter didn't kill him, because he used so much of it that amount was normal for him. While that would kill you or me, not somebody who uses it regularly, he was an addict, but that didn't mean he deserved to die. That didn't mean that Chauvin could still sort of pin him to the ground with a knee on the neck and extinguish his life from him just because he was an addict. And so, you know, this is something that's very important in all criminal law. You deal with a lot of bad facts. Law in general. There are bad facts in all cases. And so when people come to our office and they say, you know, gosh, I actually did that. What can you do to help me? And all of these things. Sometimes we have good facts. Sometimes we have bad facts, and we just have to deal with those things. Here, the government has a pretty bad fact. It was a toxicology report that George Floyd had 11 nanograms per milliliter in his blood of fentanyl, which is enough, according to many studies, to cause people to die. And the government has to deal with that. How are they going to do that? Well, you can see the theme that's already developing. This is why the prosecutor is asking the jurors about this. What's your opinion on addiction? And sort of trying to gauge how they would respond to that. Do they think that all addicts are, you know, morally wretched people who don't deserve any compassion, that they should just sort of be thrown out of society? There's still a lot of people who think that way. They think alcoholics and drug dealers are drug addicts and sort of the dregs of society, whereas other people might say, no, it's a medical problem. It's an addiction. It's something that needs treatment. It's something that needs rehabilitation. And so you can sort of pin people down. Where on that spectrum are they? Where do they fall? And Prosecutor Steve Schleicher was doing that. Certainly, he wouldn't want anybody on the jury who said something like, well, anybody who uses drugs is a drug addict and they get what's coming to them. If that is somebody's perspective on drugs, that's not a good juror for the government. Here, she says, well, no, I mean, anybody can be susceptible to this stuff. I'm not trying, it sounds like she's sort of understanding about addiction and a little bit more compassionate. And so she may buy into the government's argument more so than somebody who would be on the other end of that spectrum. So she is now on the panel. We also have another African-American woman. The day's second new juror is a grandmother and a retired marketing professional who volunteers helping children in need with their homework. Sounds like just an outstanding woman. She said she started watching the video of Floyd's arrest, but stopped after 4 to 5 minutes because it wasn't something that I needed to see, as I shut things off, things I see in the news. The woman, who is black, said she has not formed opinions about either Chauvin or Floyd and was firm in saying news of the settlement would not affect her commitment to being an objective juror. As with many jury candidates, the woman was asked about her impression of Black Lives Matter. She responded, quote, I am black and my life matters. She disclosed that she has a relative who is on the Minneapolis police force, but they have not spoken about this case or any experiences in law enforcement. The woman did not consider herself particularly close to the relative, yet added, I am proud of my relative for standing up and being a police officer. So you kind of got, an interesting dynamic here. You've got somebody who is African-American that as we know, the prosecution, I think, is really in favor of them being on the jury. They were challenging the defense striking anybody who had any background of minority status, trying to say that they were doing that on a racial bias. And so the government wants African Americans on the panel because George Floyd was African American, and sort of the racial procedure that everybody is thinking is sort of common understanding is that they're going to be able to identify more with George Floyd than a white person would. They'd be more likely to convict Derek Chauvin for killing somebody who is a part of their community. And so here, she kind of has connections to law enforcement, which the government doesn't like, but she's also African-American, which the government does like. And so no peremptory strikes were taken out by the prosecution, none by the defense. And so she is also on the panel. She's the second juror that was added today. Lastly, our third juror on the panel is a suburban woman who works in the insurance industry. Like others, she has viewed the bystander video and was aware of the settlement, but said those would not be factors in her maintaining fairness and objectivity as a juror. The woman wrote in her juror questionnaire months ago that she didn't believe Floyd deserved to die and police didn't need to use excessive force. However, she continued, Floyd was not completely innocent. She said she has generally positive views of police and opposes any defunding of their departments, yet also believes people of other races get treated unfairly by law enforcement. Another line of questioning for her dealt with drug and alcohol addiction. As we can see, the prosecution is asking this, a topic the nurse put on the jury earlier Thursday also addressed. This juror said, I understand there are people that struggle with addiction. That doesn't make them a bad person. If someone uses drugs, I don't think there should be ramifications for that. So on that spectrum of drug use, she's on the more compassionate side. She's not going to hear evidence that George Floyd had several drugs in his toxicology report and judge him unfavorably accordingly. She says, look, I don't think there should be ramifications for that. I know people struggle with addiction. She's viewing it more compassionately. And so even though she has some statements here that say, well, people of other races get treated unfairly, which may sort of hurt the defense, she also says she's got generally positive views of the police, which Derek Chauvin is. And so she's sort of looking at him through a light, maybe with a little bit of favor in that direction. The glass is half full rather than half empty, according to her view of the police, let's put it that way. And so kind of another one that's a little bit tricky to figure out where she's ultimately going to end up. And she's on the panel, so we'll see where that goes. Now, we're going to do a quick summation of this. We're going to note here that the Star Tribune posted that through Thursday, the jury consists of 6 people of color, 6 people who are white, more specifically, 1 multiracial woman in her 20s, 1 multiracial woman in her 40s, 2 black men in their 30s, 1 black man in his 40s, 1 black woman in her 60s, a white woman in her 40s, 3 white women in their 50s, a white man in his 20s, and a white man in his 30s. So they did a nice summation for us. These are what the emojis look like. So this is what the panel is looking like right now. You can see 1, 2, 3, 4, 5, 6 people of color, 1, 2, 3, 4, 5, 6 white individuals, and we've got 2 more left. And so pretty even panel. And so my thought was, Robert Barnes actually brought this up on our live stream yesterday, saying that the jury is looking much more diverse than even the city itself or even the state itself, which I thought was a very interesting concept. So I looked it up. And here on the United States Census Bureau, not the Senate, the U.S. Census Bureau. This is from Minneapolis. This is from the census.gov website. And you can see here that in Minnesota, race and Hispanic origin, white alone is 83% of the population. Black or African American, 7%. American Indian, 1%, Asian, 5%, and Hispanic, 5%. 2 or more races are sort of broken down. Native Hawaiian, 0.1%. So generally speaking, we've got 83% white and we'll say 17% of a different demographic. And this is a 50-50 panel. So it's significantly more diverse than the state of Minnesota, which is interesting. Not a bad thing, not a good thing, just interesting. So if the trend sort of continues, if we have numbers 13 and 14, maybe split it, it might be lopsided one way or the other, but it's pretty dang close to even. So it'll be very interesting to see how many people are claiming racism one way or the other after this trial is over. Here it is, plotted out on a chart. This is the emoji chart that we have. So you can see here, the last 3, we have a white female in her 50s who's a nurse. Life experience as a nurse matters, she says. She's not an expert witness. As we know, she's not going to try to pretend to be one. We also have number 11, a black female in her 60s. She's retired, marketing professional. She turned off the Floyd video because she couldn't watch it. Did say that she has some positive thoughts on BLM and has a police relative. Number 12, don't know her age yet because she just got signed up here at the end of the day, right before I came on the program. So I don't know her age yet, but she's white, female. It says Floyd not completely innocent, but excessive force is also bad. So we're getting close on this jury stuff, which is good because tomorrow is Friday. Hopefully we can close this out, and then they'll have a little bit of time until the trial starts on the 29th. But today I wanted to show you the final few minutes of court today. Very explosive a little bit, and I want to frame it out. Judge Cahill was not happy about what's going on here. So yesterday and maybe earlier today, there's a lot of conversation about some of the outstanding issues that need to be settled in court. One of the big ones is, as a result of the settlement being passed by the city council, one of the things that the defense attorney, Eric Nelson, is communicating about, he's saying, we need a change of venue. We need a continuance. We need a change of venue because this is so improper. The entire city is now biased against Derek Chauvin based on the conduct of the city council, releasing the settlement agreement right in the middle of voir dire, which is jury selection. I think he's got a very good point there. And as this has been going on, he's been bringing up other issues, saying things like there are press conferences. Oh, the city is also doing this. They're also holding a press conference. Oh, some news reporting company said that somebody who is a part of the city council or somebody who's a government official or something and so on made a statement about this trial or discussed George Floyd in some capacity, discussed Derek Chauvin in some venue. And he's trying to make the claim that he's seeing a pattern of malfeasance. He's seeing the city not just sort of inadvertently release a settlement agreement in the middle of jury selection and just go, oh gosh, we are just so silly us. We kind of biffed that one, didn't we? But that was our mistake. It was an honest mistake. We're sorry. Now, Eric Nelson is saying, no, this is orchestrated. He's saying the city is repeatedly getting really close to this line where it's becoming improper. In other words, we can't have a trial here because the city itself is hostile to our client. And he's trying to show the pattern by showing different news sources, different articles. The whole city's talking about this case, apparently. And so as this is all proceeding, as they're going through jury selection, Eric Nelson, the defense lawyer, is calling to the court's attention certain issues. He's saying, look, this person talked about this. They're a part of the city. They're showing bias and prejudice towards our side. And again, and again, and again. And so the prosecutor here, now Steve Schleicher, he's unhappy with this. He certainly does not want the venue to change. He wants it right there in the middle where it happened because of a lot of different reasons. You can speculate about that. Maybe he thinks it's favorable for his verdict. Maybe he thinks the demographics are better. Maybe he thinks that the public pressure will help sway people to his line of thinking. Who knows? Could be many different reasons why, but he does not want it to leave. And so Eric Nelson is continually bringing up these issues. City council's doing this, government officials doing that, mayor's doing whatever. And so the prosecutor comes out in front of court today at the very end and says, listen, Judge, we got to get a little bit clearer with the record here. Okay. The defense attorney, Eric, over there is just sort of shooting from the hip. He's just kind of coming off the cuff. He's saying, well, this city council member did this and this judge did that, or this mayor did whatever. And he goes, that's not good enough. We need stronger records. We need to go in and submit an offer of proof. He can't just sit there and just sort of run his mouth is really what he's saying. He can't just sort of, come off the cuff and point these things out to the court. He needs to go through a formal procedure. He needs to submit a motion. He needs to submit a notice. He needs to document this because right now he's being too loose. Judge is not happy about that. So the clip that I'm going to show you is the prosecutor. He's going on for about 2 or 3 minutes, and then he's sort of reiterating this point that Eric Nelson keeps saying things that are not being documented to the prosecutor's liking, not to the judge's liking. The judge hasn't issued any ruling or any order about how this stuff should be communicated to the court. But what really in my mind is happening is the prosecutor really wants to shut him up, essentially. He's asking the court to say, hey, I don't like how he's bringing this to the court's attention, so please tell him to stop that. Goes on for about a few minutes, and we're going to pick this up at the tail end where he's sort of coming off of his argument, saying that there needs to be more evidence presented because it needs to have more context, and he can't just sort of shoot from the hip and off the cuff. And the judge cuts him off and then goes into his little explanation and then storms off the bench. It's a good one. Let's take a look here. Here is Judge Cahill.
And then I would also ask, Your Honor, again, just emphasizing the importance of maintaining an accurate record. To the extent that the court is going to be relying on anything. I mean, off-the-cuff comments about something that someone may have reported in the media, that's really third-hand information. I think that if counsel is going to be making factual assertions, they need to be made as either a formal offer of proof or a declaration with supporting exhibits attached. And I don't think that the court has limited in any way defense counsel's ability to file articles, newspaper articles, or whatever kind of accounts he thinks is going to support his motion. But just simply in the middle of proceedings saying, hey, I heard that the city council is talking about this case again, without the context in which it's being spoken about, is just unfair.
Let's just stop right there. As an officer of the court, Mr. Nelson was noting something that was in progress almost. He has the right to do that. You have a right to criticize it as not being sufficiently supported by declarations and affidavits. My response to his declaration was to say it was noted, nothing more, no finding. And I would expect that he follows it up with perhaps some filing. I cannot expect Mr. Nelson to step out of these proceedings, where we've been in session since 8:30 this morning, to file affidavits to add to his record on a motion I'm going to be reading about and deciding tonight for tomorrow morning. I don't think it's fair to criticize either side. Either side. You should not be criticizing each other for noting for the record things that are happening in an emergent manner. It should be followed up. I agree with it. Good record is much better. But for an officer of the court to make a notation, he's entitled to do that. Whether he wants to just rest on that is fine. I think your answer to give me that transcript and a URL to listen to is also very appropriate, very important for me to look at these questions. But let's recognize the fact that the state has a lot of lawyers on this case who can sit outside this courtroom and start grinding out things. Mr. Nelson does not. He does not have the same level of support. How many lawyers now are admitted pro hoc VJ and are working for the state on this case so far, Mr. Slisher? Is it 10, 12?
I don't have that number, Your Honor, but I do know that the Police Federation, the union, is funding the defendant's defense, and they have...
Let's not talk about that. We're not talking about how things are funded. I'm just saying, I can understand why what I'm saying is, I can understand why the state is able to produce affidavits and memos so quickly, because there are a lot of lawyers working outside this courtroom. I can't expect that Mr. Nelson would walk in this afternoon with affidavits when we've been in jury selection all day.
And
I think what we're getting into is criticizing each other's performance. Let's not do that. You do your own performance, you let the court evaluate whether it's enough. We're going to go forward, make your record, make it as good as you want to make it. I'll decide based on the record that's before me, and if it's not good enough, I'll say so. And to be honest, I'm not going to talk about this second press conference. I'm not going to talk about it. Make your submissions. I prefer now they be in writing, and we stop talking about it. I've asked Minneapolis to stop talking about it. They keep talking about it. We keep talking about it. Everybody just stop talking about it. Let me decide what the ramifications are. Are we clear on this? We're adjourned for the day. Submit your additional submissions in writing. Not oral. Thank you. 8:15.
Mic drop off the bench. Get it together. See you tomorrow morning at 8:15. Just gets off the bench. Yeah, typically judges don't do that. When you see them do the spin around, the boom, and they're off. They're not happy. He's not happy about it, and nor should he be. And this is pretty typical from prosecutors. They like to come out there. They've got all the resources in the world. They've got massive law enforcement budgets. They have hundreds of employees in their prosecution offices. This team, as we have seen, is flying in private lawyers from all over the country, from Yale and Harvard and all these different massive law firms. They're all flying in there to join the team, and they're all sitting outside the courtroom just, going hard on all these different motions. Eric Nelson sitting in there with Derek Chauvin just going, oh, okay, we're going to get up there and we're going to argue whatever we can argue. And you can see here the government is using different prosecutors for different areas. They have like one prosecutor for each different defense expert for all the different motions that are coming up. They're segmenting the case so that one person can work on one issue and go and just crush it with that line of questioning. Eric Nelson is sort of having to, fly around all over the place and just tread water. Now, he's doing a great job because he's used to this stuff. This is just how life is for defense attorneys. It's always a David versus Goliath situation. And as you can see here, the prosecutor comes back out and says, oh yeah, well, he's being funded by the police unions, which I detest, by the way. And that's fine. But the judge says, listen, we're not talking about funding here. Okay. We're not talking about that. We're talking about you and how you're conducting yourself in this courtroom. Mr. Prosecutor, if you're not happy about how he's making a record, well, you're entitled to correct the record or make a record, but don't come in here and cry to daddy and say, Dad, he's not doing by the rules. He's not playing fair, and I want you to go and correct him. The judge said, you're a grown-ass man. Pull it together. If you don't like what he's saying, make the record clear, and I'm going to be the one who judges it. Okay, Eric Nelson's doing what he can. These are emerging issues. The city council keeps talking about this stuff. I'm tired of talking about it. You're tired of talking about it. So submit your briefs. I'm going to rule on them tomorrow morning, and have a good night. Boom, mic drop, I'm out of here. And I got to tell you, I absolutely think this is just outstanding. Outstanding. I mean, this judge is really fair. Prosecutors do this all the time. They complain all the time about a bunch of nonsense. And this judge knows that, practically speaking, This is how a trial works. And I think it's very, very disingenuous of the prosecutor to say, oh, you really want Eric Nelson to bring out all of these issues on the fly? You want him to sort of ask the judge for a break so that he can go out there and write an affidavit or submit a notice or file a written motion? You know how long this trial would take? And so the prosecutor is trying to chill that speech. They're trying to shut him up. If the judge would have come out, and the judge easily could have said, hey, Mr. Nelson, you know, he's right. We got to be very careful with our language. This is a volatile trial, and we need everybody to just make sure that all the T's are crossed and the I's are dotted. And so I'm going to ask you to refrain from bringing this stuff up to our attention unless it is a formal written motion. If it is a formal document, then we'll consider it. And if he would have done that, which a lot of judges would have, then Eric Nelson would have had his hands tied behind his back. He wouldn't have been able to call any of this stuff out because he can't be in two places at once. He's in court. They're trying to do jury selection. They're trying to move this thing down the road. And if he would have had to have taken a break at every single time that he got some news about something that the stupid city was doing in order to derail the trial, then the whole trial would be derailed because he would have to step out of court in order to go submit those documents. And the judge knows that. And this judge, fortunately, saw through it. He said, look, Mr. Prosecutor, quit your crying. Okay, make your record. Stop criticizing him. Stop trying to tell dad how to treat the other child. I'm running the courtroom, and that's it. Deal with it. And so, I mean, major kudos to this judge, somebody who is fair. And I think what the prosecution was trying to do is very transparent. They were trying to chill Mr. Nelson's ability to represent his client by taking one of the tools away from him that he would have submitted in order to support the motion for the change of venue. It's underhanded. This judge called him out on it, and it's not a good look for the government. Not good. And hopefully they take that little bit of a backhand and pull it together for tomorrow. Let's go over to the questions here from locals. What's for locals? Watchingthewatchers.locals.com. Sorry, I was reading the question to myself and not to you. Liberty or Death says the media airing details of security is the same as Geraldo airing the troop movements that led to 2 soldiers being injured in the Gulf War. How long do you think we will have actual journalism again? I think journalism is just, I mean, as an institution, I think it's probably on the way out. You have a lot more people, I think, who are doing, I mean, there's always going to be journalism, but I think traditional journalism is being just edged out by independent journalism. I mean, look at this Substack versus, New York Times, for example. People are going to Substack. I subscribe to a lot of people over on Substack. Well, not a lot, a handful of people over there. And it's better than anything you get elsewhere. And so they're all freaking out about it. They're all trying to stay relevant. And I personally will not be missing them when the time comes. Next up, we've got Build a Wall says, assistant is Keith Ellison. Keith Ellison is Attorney General. Okay, so the assistant is Keith. Oh, he's one of the assistants. Oh, okay. Oh, no kidding. I didn't even realize that. Okay, Keith Ellison is the Attorney General. All right, good. Thank you for that correction. I had not heard him speak in court. I just saw him stand up and introduce himself on the I think it was the first day, just kind of stand up and nod. So I hadn't heard him speak. So, all right, thank you for that. We'll make that correction. And I appreciate that, by the way. There are things that I'm missing on here. I've got, I'm doing my best, but there are things that I'm going to be missing. So if you see it, if you're paying attention to this and you see any corrections or any errors, especially in the jury panel, if you find other news sources that give us some details where we can fill in some of the gaps on our demographics or our professions or age or any of that stuff, please feel free to send that over to me. I'm going to be updating this. I can't read everything. Obviously, I'm not there. I am pulling from the Star Tribune. And so if they are off or you have better information from somewhere else, I would appreciate you sending that over. So Liberty or Death says, I have seen defendants with a number of co-counsel, but is this normal to have so many prosecutors? Yeah, it's a good question. This is not normal, but nothing about this trial is normal. I mean, this is all kind of a first impression. This is the first time that I've ever seen a trial that is this transparent with all the documents publicly available. Everything is being live streamed, everything from opening announcements to the close, the end of the day. It's all available. And this is also something where security is beefed up. We've got a lot of very complicated issues. The entire country is focused on this. So I know it's not normal, but it's also not surprising. They have a lot invested in this case, so they're going to be spending a lot of resources in order to beef that up a bit. Jack Alaya in the house says, I've been on a jury where the instructions of the judge to guide deliberations were ignored in favor of personal experience and political leanings of most of the members. So should an actuary be the foreman controlling authority of a jury determining the amount, if any, of compensation the victim of an accident should receive concerning a life-changing injury? So, should an actuary be the foreman controlling authority of a jury determining the amount, if any, of compensation? Well, that sounds like it's a civil law question. I can't really opine on that. I've never done a civil jury trial. I've never done really even a litigated car accident case. I just haven't been in that field. But certainly, personal experience should not displace the jury instructions and the law. If the law says what the law is, then the jurors don't get to throw that out in favor of their personal opinions. That's not appropriate at all in criminal law or civil law. Sliding Edge says, genuinely appreciate you speaking with Barnes and Frey yesterday. Appreciate your efforts. Question asked yesterday. Any more discussion about settlement resulting in mistrial? And yeah, it's a good question, Sliding Edge. I don't think so. And the reason why I don't think so is because they're doing basically everything that they can to keep that out of the formal proceeding. And so I'm not sure that a court is going to grant a mistrial just for that basis. A mistrial is typically something that happens in the middle of the trial or leading up to it, or something procedurally sort of within the bubble of the trial. Here, the judge is doing everything possible to make sure that the settlement is kept outside before the trial starts. And so I'm not sure that the settlement itself would justify a mistrial just due to the fact that they released it. Now, if they do something else, let's say in the middle of the trial, that might be more, that rattled the existing jurors, then that might be something that would justify that. But at this point in time, I just don't see that. It's a huge problem. The judge is obviously not happy about it. That's why they got rid of the 2 jurors. If they were not able to get rid of the 2 jurors because they had already been impaneled, then yeah, that might have been a mistrial. But the judge is able to correct for this problem in court, and so I'm not seeing that there's a potential for a mistrial, but it's a good question. News Now, Wyoming, last question on this segment says, I have said from the beginning of jury selection that I don't think he can get a fair trial anywhere in Minnesota, but certainly can't receive one in Minneapolis. I want the guy found guilty, but I like our civil rights more. It's a great point, and it's a great perspective, News Now. I am of the same mindset. I am not a fan of Derek Chauvin. I'm not a fan of the police, right? My whole job is going against the police. So I sort of see this, I'm sort of predisposed to not identifying with Derek Chauvin. I am, however, very identifiable with the presumption of innocence, due process, right to counsel, right to a fair and free trial, something that involves impartial jurors without any malfeasance from the government. I don't want, multiple different bureaucracies dumping on somebody. I don't like the media pre-convicting people, and it's messy. And so I think that those things are more important than any particular criminal defendant. We have to remember the values that make up the justice system, the foundation of the justice system, I think are more important than any one prosecutor, any one judge, any one defendant. And we got to make sure that those things are upheld. And that's really my big interest in the Chauvin case. We'll see where it goes. All right. So that's it for Derek Chauvin. Explosive last couple of days from a lawyer's opinion. If you're not a lawyer, you may look at this, you go, this is the most boring thing I've ever seen in my life. But I might even agree. I might even agree with you on some days. But this has been very, very, very fiery over these last few days. And so we'll see where that goes. One of the things you have to consider is this a judge who's just getting irritable with the government? They're not going to like that if that is the case. And I don't think that this judge is somebody who's going to try to punish the government because he's agitated with them. But it's certainly, he's only human. And if he's going to be agitated with the prosecutor for 4 weeks in the middle of a trial, they may lose some objections. They may lose some, emotions that they need to win in order to be successful in the case. And you don't want an irritable judge. They're not doing anything to prevent that from happening. So, all right. So that's Derek Chauvin. Let's change gears a little bit. There is a local judge from Milwaukee, goes by the name of Brett Bloome, who was just arrested on 7 counts of child pornography. A judge arrested, 7 counts of child pornography. This story comes over from opindia.com. Let's go through it. as I mentioned, this is not a fun story because there are children involved. Local judge and former president of a foundation that runs Drag Queen Story Hour for children was arrested on 7 counts of child pornography. Milwaukee County Children's Court Judge Brett Bloome was endorsed by the LGBTQ Victory Fund for his position as a judge. Guy was a judge at a county children's court, was arrested on Tuesday and charged on 7 counts of possessing child pornography, specifically depicting the sexual abuse of young boys. Brett Bloome, who is 37, is also the ex-president of the Cream City Foundation. What the hell is that? A LGBTQ plus organization which is known for hosting Drag Queen Story Hour, a highly controversial event where men dressed as women in drag attire, they read out stories to little children. Oh, good. This is kind of what it looks like. So we have the children blocked out in this image, as you can see. We have the Cream City Foundation, which is one of the most bizarre things I've ever seen as a name of an organization. That is a disturbing thing. So here we have Drag Queen Story Hour Milwaukee. So we have, I don't even know what to call this to be politically correct, but you have an individual here who is dressed in a certain attire. There are children around this event. This was, I think, was posted on their website over at urbanmilwaukee.com. There's a press release. So this is all on their website. Drag Queen Story Hour is just what it sounds like. Drag queens reading stories to children in libraries, schools, and bookstores. DQSH, Drag Queen Story Hour, captures the imagination and the play of gender fluidity of children and gives kids glamorous, positive, unabashedly queer role models. Spaces like this, kids are able to see people who defy rigid gender restrictions and imagine a world where people can present as they wish, where dress up is real. Mission, a fun and entertaining way to educate all ages about progressive social justice and human growth and development issues through literature and reading. The impact, it's open to the public to engage the widest audience, LGBTQ plus visibility in areas that lack representation, point of first contact for families seeking LGBTQ plus information, provide safer spaces for children to express themselves, intersectional reading list that covers a range of topics, educating families together and as individuals. The events are family-friendly fun. So on their website, there's, obviously very young people, young children, I'd say, 2, 3 years old, who are attending those things. Okay, so this is the guy. He is Brett Bloome, announces endorsement from LGBTQ plus Victory Fund. National organization endorses Bloome because he will be a strong voice for equality when elected. So this was posted back on March 2nd, 2020 at 4 a.m. From Milwaukee, today, LGBTQ Victory Fund, the only national organization dedicated to electing LGBTQ people to public office, endorsed Brett Bloome for Milwaukee County Circuit Court Branch 5. The endorsement signals the Victory Fund's confidence that Bloome is well positioned to win the judicial race, will be a strong advocate for equality once elected. He would be the only one of 2 openly gay men in the Wisconsin judiciary if he wins. And there's a quote here. LGBTQ Victory Fund is pleased to endorse Brett Bloome for the Milwaukee County Circuit, said Mayor Anise Parker, president and CEO of the LGBTQ Victory Fund. Brett is a passionate advocate for fair and impartial sentencing and understands that every decision impacts the lives of real people. When he wins on April 7th, he'll be one of the just a few openly LGBTQ judges in Wisconsin, will bring important perspective to cases that come before his court. According to list of officials maintained by Milwaukee, Bloome is assigned to the Milwaukee County Children's Court. So Brett R. Bloome. Deputy Court Clerk is Annie Grenier. They're in this room, this phone number apparently. Milwaukee County Courts, list of court officials, Branch 5, the Children's Court. Okay. The charges against Brett Bloome are serious, with each count of child pornography carrying a minimum mandatory prison sentence of 3 years to as much as 15 years in prison. After spending a night in prison, Bloome has now been released through signature bond. So he's out of custody. So so he gets out of custody. Jacob Chansley, though, or anybody who was involved in the Capitol Hill riots, they're all still in custody. All right. Some of them weren't even there. So there you go. We have mandating that Bloome not to use social media or file sharing services or have unsupervised contact with children except for his own. He's married to a man and has 2 adopted children. The criminal complaint against him details that up to 27 images and videos of minor children being sexually abused were uploaded to the messaging app Kik. The location for these uploads were tracked back to Bloome and husband's house in Cottage Grove, Dane County. So 27 images, let's say times maybe 3 per image. Each count of child pornography carrying up to 3 years. He's got 27 images. Maybe that's 27 counts. That's a long time. Endorsed by the Democratic Party. Brett Bloome was handpicked by Democrat Milwaukee Mayor Tom Barrett, probably regretting that decision, as a candidate for the circuit court, with Tom Barrett urging fellow Democrat and Wisconsin Governor Tony Evers to put his name forward to the opening of the county circuit court in 2019. Milwaukee Mayor Tom Barrett cited his 20-year close relationship with him. However, he did not appoint him to the open position on the court. Eventually, he would go on to win, being the first openly gay man to do so. The election would not be possible without a string of ringing endorsements in his favor, the vast majority of which were Democratic endorsements. In his race, Bloome described himself as a progressive alternative to his opponent. To kick off his campaign, Brett Bloome boasted early endorsements from a whole host of elected officials, attorneys, and community leaders, the most prominent being Democratic Wisconsin Senator Tim Carpenter. He was appointed the CEO of Creamy City Foundation, an LGBTQ plus organization which includes highly controversial drag queens. I cannot get over that name. He was elected judge. However, this was not easily accessible. In June 2000 and left just before he was elected as judge. This is not easily accessible information. This is because the news of Bloome's arrest for child pornography has come out. Various online web pages were scrubbed. Everybody's abandoning ship, which tied Brett Bloome to Creamy City Foundation. His LinkedIn profile has been purged with only a screenshot confirming his role as CEO of the Creamy City Foundation existing. There it is. President, June 2007, 3 years, 3 months to 2020. President, CEO, 15 years in philanthropy. Before joining CCF, served as the director of major gifts for the AIDS Resource Center of Wisconsin. And he's the circuit court judge. So they're trying to scrub everything, rightfully so. All right. The Creamy City Foundation has deleted all references to Brett on their website. Op India was able to secure a cached version of his author archives on the Creamy City Foundation website, which have all now been scrubbed. As an author, Bloome has advocated far-left positions on gender and sex, choosing to write articles about topics such as transcultural competency training. So we have here, author archives for Brett. Join Cream City Foundation for Giving Tuesday. 2020 scholarship recipients announced. 12th annual business equality luncheon slated for October 16th. Oh, look pretty benevolent. Now that his grievous offenses of possessing multiple images depicting child pornography have been revealed, many poignant questions arise about his activities as CEO. As the CEO, he was overseeing several events, including Drag Queen Story Hour, with a great many minor children in attendance. If he's convicted of the child pornography cases, it raises serious doubts regarding the safety of children at these events and how a suspected pedophile was in charge of putting these events together. It's a good question. Isn't it a good question? I think it's a pretty good one. Milwaukee County Circuit Court judge was charged with possession of child pornography. He won election April 2020. Term is scheduled to end July 31st, 2026. Those are long terms. Bloome was held in the Dane County Jail and made an initial appearance on Wednesday afternoon. A court commissioner set a $500 signature bail. Oh my. He has not yet entered a plea. He was released from jail shortly after 4 p.m. on Wednesday. If convicted, he faces up to 25 years in prison on each count. 25 years on each count. He will be back in court April 19th. No other details have been released. Milwaukee County Chief Judge said his court schedule would be covered by another judge starting Wednesday. His duties were suspended on Wednesday by the Wisconsin Supreme Court. So 25 years in prison on each count. He's got 7 counts. That's a lot of counts. That's a lot of time. This is over from State of Wisconsin versus Brett Bloome. Filed yesterday, March 17th. Prosecuted by the Attorney General. Next court date, April 29th. 7 counts of child pornography. Does this look familiar? This case docket? Yeah, it's the same one as Rittenhouse's. We've spent a lot of time on that one here also. So 7 counts times 25 years. It's a lot of time. I don't do math, but that's a lot of time. Here's what's going on in the case. As we can see, the initial appearance was on March 17th. Let me move myself up out of the way there. Defendant is in court in custody with attorney. So he's already got a lawyer, Christopher Van Wagner. David William Moss appeared for the government. All parties by Zoom received a copy of the complaint. Signature bond. Your signature bond in the amount of $500 per case. You may be responsible for paying this amount if you miss a court date or do not follow conditions of your release. Defendant shall not have access to social media or file sharing, not have any contact, direct or indirect, with a minor unless supervised by a responsible adult. Contact with children, the defendant to be allowed without supervision with his own children. Parties stipulated to waive the time limits for the preliminary hearing. Another preliminary hearing, April 29th. Another Zoom conference, signature bond, all happened on the same day, all on March 17th. $500 bond. Guys facing well over 100 years, potentially. $500? Crimes involving children? It's interesting because Jacob Chansley, who we're going to talk about next, walked into a Capitol building with a spear, and he's still in custody. That's kind of weird, right? All right. Well, just my thoughts. All right. Here is a clip from the court proceeding that took place on the 17th.
Please, the court and counsel. Let me start with the cash bail. I respectfully believe that the bond should be a signature bond in this case, and I'll state my reasons quite simply. My client, as identified in the report the court reviewed, has no prior record. He is a resident. He is not only a resident of the state of Wisconsin, he owns 2 residences here. He has substantial ties to the community. He is in a marriage and he has children, and he is committed to them. And regardless of the, if you will, the seriousness of the charges or even the potential penalty, the presumption of innocence is still part of this proceeding. But more importantly, the simple question would be, why is he any different than anybody else who was for the first time accused of a child pornography offense in this county? Those are cases that ordinarily result in a signature bond, absent evidence of attempts to flee. There are none of those here. So as a practical matter, I'm prepared to address it more, but I don't think that, let's put it this way. He's a professional. He does own a home. He has no particular place to go but here. The state hasn't suggested any indication that he would go anywhere. And so the imposition of $2,500 cash bond is hardly the kind of anger that would keep somebody here who is as smart and as experienced and as professional as he is. On the other hand, there's nothing about a signature bond that is going to cause him to suddenly up and leave his family, leave his extended family, and leave the support group he has among his friends. He has a wide group of support, and that won't change after today.
All right. So very, very standard argument there. Ties to the community, not a danger, not somebody who's a flight risk, married, kids, has a home, all of that good stuff. Very standard. I can't speak to this on obviously Wisconsin and how their laws work or how easy it is for somebody accused of those crimes to get out of custody and go back home and be sort of available in the community. And I don't know the nature of his case or what the allegations are, but they're pretty serious charges. It's a pretty serious offense. Anything that involves children, typically, at least here in Arizona, it's categorized as what's called a dangerous crime against children, which is a whole separate can of worms. I mean, it's a very, very serious category of offenses that typically doesn't result in somebody just signing a document, posting $500 and getting out of custody. But this guy is a judge, and he's part of a demographic that has a lot of political power. And I don't know if any of that has to do with anything or if this is just how things work in Wisconsin. But I will tell you this, it doesn't feel, one of these things is not like the other. And many people who are charged with this, they don't get out of custody, just period. Or if they do, it's on very, very serious restrictions with very significant monitoring because they don't want that to happen again. This guy's a judge. He's got, massive endorsements from everybody. It sounds like there, a lot of the Democratic leadership in order to get him elected into that position. Now everybody's wiping the slates clean. He's out of custody. And it just feels a little bit easy for him when many other people in this country never get that benefit. Never, especially for 7 counts. All right. So what are the courts going to do about this? The Supreme Court of Wisconsin says that they're going to basically terminate him temporarily or put him on a suspension. So they issued this order basically the same day that the charges were filed to Honorable Brett Bloome from the Juvenile Justice Center. And it's going over to a number of other people, the state director of courts, the judicial commission. We've got the chief judge of District 1, deputy chief, and on and on and on. Circuit court, district court administrator. So they're notifying everybody. You are hereby notified that the court has entered the following order. It says here, the court has learned that the Judge Bloome has been charged with felony criminal offenses. The court is charged in Wisconsin Constitution with exercising, superintending, and administrative authority over the courts of the state. In the exercise of that authority, and in order to uphold the public's confidence in the courts of this state during the pendency of the criminal proceedings against Judge Bloome, we conclude that Judge Bloome is currently unable to properly discharge his official duties and that the public interest requires that he temporarily be relieved of those duties. It is ordered in the exercise of this court's superintending and administrative authority over all courts in this state that he is temporarily prohibited from exercising the powers of a circuit judge in the state of Wisconsin, that his salary is temporarily withheld effective this date until further order of the court. So, all right, let's take a look at some questions over from watchingthewatchers.locals.com. Let's make sure these are acceptable questions for this topic. Liberty or Death in the House says, you could call it a drag queen story hour. Disgusting. I would be pissed if my daughters were subject to this nonsense. But hey, our side is the one that denies science. Yeah, I can't even believe that's a thing, honestly. I'm sure I'm a bigot because of that, but I just can't. I don't have kids, but I am a godfather to one young man, and I know others, and that doesn't feel okay to me, but all right. Remark says, how embarrassing for Wisconsin. No doubt a Democrat. Yeah, clearly got a lot of support from them as well. Not that that necessarily means that all Democrats are, okay with that. I'm not saying that at all, but it is not okay. We have, Sharon Quinney says, on Cream City. Wisconsin is noted for its dairy products, and dairy farming is a big industry there, hence the name. The double entendre is, well, better left unsaid. Yeah, that's where I was going with that. How did they even justify using that name in general? That makes sense. Cream City. Oh, my God. Eesh. All right. We have JBone86 says, it really instills great confidence in the justice system when an alleged child sexual predator can get $2,000 bail while staring at 25 years in prison. Meanwhile, folks charged with trespassing at the Capitol are locked up until trial. Yeah, that's just how it works. You have certain protected individuals in this country. Some are from a favored political demographic. Others are not from a favored political demographic. And the justice system is now weaponized so that certain individuals get off with a $2,000 bond, or $500, I think it was. And that's it. He's free. He can do whatever he wants until trial happens. Everything is getting cleaned up. Everything is going to be fine. All right. Liberty or Death says, I really do not like this stuff because a judge is gay or black or one-eyed or horned or flying purple people eater. They will bring a different perspective to the bench. How about they will preside over a case according to what the rule of law is and not what they want it to be? Yeah, I know. Just XUXA says, how would you go about defending this case? So disturbing. Yeah, it would be disturbing. Look, I've worked on these types of cases. Okay. Typically it goes a lot differently than this. Okay. People are not let out of custody. They are, a lot of these cases tend to be about helping the family through the process more than the defendant, but he's out of custody. I mean, this whole thing, maybe he's going to get a slap on the wrist. I don't know. It's a good question, just XUXA. That's for a whole different show. Jeremy Matrita says, if he was only released on a measly $500 signature bail, I bet he gets sentenced for time served. How on earth can such a low bail amount even be legal? Okay, the judge's attorney makes some good points. I still think that $500 bail doesn't sound right, and certainly not what your average person would get. It's very low, right? $500 is very low. Now, again, I don't know what it's like in Wisconsin. I don't know if this is standard. Maybe this is standard. Maybe just all the child pornographers out there just get $500 bond and go, oh, you again? What are you doing here again? Get out of here. Just sign that form. Get out of here. Ish. Yeah, I don't know. I mean, I would think that if you're the people of Wisconsin, you're looking at this. And listen, look, I am not for holding people in custody indefinitely. I'm not at all. but I am for equal application of the laws. And I think that this is something that is a lot more serious than somebody walking into a building and looking around for a little bit of time, personally. But I'm not in charge of these things. JBone86 says, Sugar Britches was uploading CP in a messaging app. Why no charge for distribution? Yeah, I mean, that might come down the pike. And depending how deep this rabbit hole goes, depending what evidence they have, I mean, they might bring the feds in and turn this thing into to something, even more serious. But right now it's very preliminary. And again, we don't know what the evidence is. And I also believe in the presumption of innocence. And I'm not trying to harangue this guy, but I cannot stand when it's people in elected positions of power, when they know the rules, they know the laws. This guy was sentencing people. This guy was dealing with children. This guy was reading to children. This guy was hosting children. And he's also in possession of child pornography. What? And he's a judge? Yeah, he's not going to get much sympathy from me because he is exploiting the rules. He's a part of the system that throws people in prison for this stuff, and he's out on he's out on bail. All right, we have Ma Fox says, okay, so that bailiff is so creepy. So I think that this is actually him. This is the judge, and the bailiff is just outside of the room with the camera pointing at him. Is what I was suspecting, but I noticed that too. Very interesting image. And if that is the case, can he hear what the judge is saying through this big, thick metal glass? I don't know, but it is an interesting image. We have News Now Wyoming says, at least he doesn't get paid. Clearly they don't have a good union. Yeah. Yeah, the police would be suspended with pay, wouldn't they? Liberty or Death says, we know that you have worked on all sorts of cases, guilty and innocent. How do you distance yourself from the facts that you don't become emotionally affected? Well, I would probably with a little bit of experience, I think it becomes easier with experience. You just start to recognize that, certain people are going to be going through these situations. Oftentimes, I will sort of recognize that people are broken. People have a lot of issues, internally. Maybe he, was abused as a child or something like that. There's always multiple sides to the story. These cases, though, are really rough. Anything involving children are just not easy. It's hard to emotionally distance yourself from it. And I know many attorneys who can't. They have kids. They have 5, 6, 7, 8-year-olds, and it's too much for them. So they just won't take those cases. I am not of that mindset yet. I don't have kids. I'm not married or anything like that. So, to me, the cases like this that I have worked on, if I can be candid about it, it's really been about representing, the family. It's certainly about representing the client. That's not what I'm saying. Your client has the utmost, you have the utmost duties and obligations to your client, the person who is the defendant. But in many of these situations, the evidence can be so damning that really what you're trying to do is mitigate it, because a lot of these people are just caught red-handed, and the defense can be difficult to build. So a lot of what we're doing is being compassionate for those in their lives, wives, families, children, brothers, sisters, moms, dads. They're just totally caught off guard by this. Here you have this judge who is a very big name there, somebody who was endorsed by a lot of different Democratic politicians, somebody who ran a campaign, got elected. And now this is like a little nuclear bomb went off. And so, a lot of what we do is sort of help to piece this all back together again for people. But it's difficult to not get emotionally invested in these types of cases because it is so heinous. And oftentimes, for criminal defense lawyers, you got to go and look at the evidence, right? You got to go look at the imagery, and that is a whole different thing. So, yeah, it's not a fun area of this field. Nothing is fun, right? Our clients are going through very difficult times. This just happens to be next level type of awful. Jeremy Matrita says a signature bond means he would be charged $500 if he fails to appear. He didn't have to pay any money to get released. Yeah. Ma Fox says they multiply the consecutive charges in bail in Wisconsin. Rittenhouse was $2 million, 2 times first degree. Yeah. So child pornography apparently doesn't have any of those mandatories, I guess. We'll see where this goes. I mean, we're going to follow this one, certainly. I'm going to see if he gets a slap on the wrist or if he actually gets the same penalty that other people would get. It's already looking like we know where this is going to go, unfortunately. Good questions. Thank you for that. Icky little segment there. So let's just move on past that, shall we? All right, last segment of the day. Jacob Chansley The QAnon Shaman, many of us know who he is from his infamous pictures from his time at the Capitol Hill riots. He has been charged with a number of different crimes. He is being held without bail. Judge has denied bail several times now, said that he's a danger to the community because he was carrying a spear, flagpole with a little pointy thing at the end of it. And he mentioned on his podcast one time that he was using psychedelics. And so the judge said that this was so reprehensible that we cannot let him out of custody. We covered that original order from the federal judge out in the DC circuit some time ago. Now, the prosecutors are asking for a continuance. 60 days, because they think that this is the most complicated case that they've ever worked on as the Justice Department. And I'm not even making that up. Let's dig into this motion. So this is the United States motion to continue the trial. And they want to exclude time under the Speedy Trial Act. So what does this mean? Okay, let me give you the high-level overview of time. Okay, in our Constitution, we have a right to a speedy trial. It's part of due process. What we try to avoid is throwing people in custody, not letting them out of custody, and then just making them sit there while the government just sits on their hands and doesn't do anything to move the case forward. I say this a lot, but justice delayed is justice denied. And so if somebody's sitting in custody and the judge will not let them out, they want to have their day in court. They want to have trial. They want to have it quickly so that they can get a resolution to this and find a home in the federal prison system or get out of custody and get back to life. And it's critically important that we do this. If you've ever seen the Count of Monte Cristo, remember that movie? Great movie, where he is locked in prison to wait his day in trial, and he sits there for, 25 years. Okay, because he's never going to get a trial because they're just going to keep delaying that. And this is something that happened in the, in sort of the old world before people came over to America and, wrote a new constitution and put this thing in there that we have a right to a speedy trial. And when we talk about this, we talk about time. And so think about it this way. If you are somebody who's been charged with a crime and you want to have your day in court, what does a speedy trial mean? How long does that mean? Does it mean a short period of time? Does it mean you have a right to have a trial within 3 months, 6 months, 9 months, 10 years? What is it? And the way that we decide that is we typically say, we can call it a 6-month window. Let's use this for an example. 6 months for a trial. That's the general rule here in Arizona. Courts want to get from the charging date to the trial within about 6 months on let's say, middle level misdemeanors, longer than that for felonies, but it's around that same level of time. So the way this works is if you are a defendant, you have the right to that speediness. And if you ask for a continuance, what you'll do is you'll waive a portion of that time. So you have a right to have 6 months and you have your trial. But if you need more time, if you want to go investigate an issue, if you want to go interview some more witnesses, if you want to go prepare new motions or whatever, then you can ask for a continuance. You can say 6 months is not long enough. I need more time to prepare my case. And as a defendant, you can do that. You can say, yes, I know I have a right to a trial in 6 months. I don't want it. I'm going to waive my time. I'm going to exclude time. So I'm going to take that 6 months as a calculation. I have a right to have my trial within 6 months, but because I asked for a continuance, I need, let's say, 30 days or 60 days. I'm going to take those 30 days or those 60 days and remove them from the 6-month calculation. It's called excluding time. We're not going to count those days against your speedy trial deadlines. So I know this is kind of philosophical conversations about time and sort of out there a little bit, but that's what's happening here. The government, if the defense wants a continuance, we will typically waive that time. We'll exclude that time so that it doesn't count against us because we asked for the continuance. When the government asks for a continuance, we want that time included. The government is trying to extend the case. Well, that could be in violation of my right to a speedy trial. If they want to move it on, if they want a continuance for 30 days or 60 days, they better count that time. That's their continuance, not ours. And so here, as we can see, the government is saying we want a motion to continue and we want to exclude time. So they want the continuance and they don't want it to count. Whoa, what's going on here? They want a continuance and they don't want it to count against them. So let's take a look at this. This was filed yesterday, March 17th, U.S. District Court, District of Columbia, United States motion to continue. and to exclude time under the Speedy Trial Act. This is for Jacob Chansley, the QAnon Shaman. The United States of America hereby moves the court for a 60-day continuance, and they want to further exclude time within which trial must commence under the Speedy Trial Act on the basis that the ends of justice served by taking such actions outweigh the best interest of the public and the defendant in a speedy trial pursuant to the factors. Okay, so they want another 60 days. Jacob Chansley has been denied bail twice now, as far as I can recall. And they also don't want to be penalized under the Speedy Trial Act. This is so reprehensible to me. Let's go through it. Here is the statement and the factual background. He's charged via indictment, crimes related to the Capitol Hill riot. We already got that. Presidential election, people at the crowd, entered the Capitol without authority to be there, joint sessions, blah, blah, blah. Capitol Hill police, other law enforcement agencies. The event is entirely here after the Capitol attack. Okay, so they're going to call it the Capitol attack. Got it. Investigation and prosecution. Look at this nonsense. The investigation and prosecution of the Capitol attack will likely be one of the largest in American history, both in terms of the number of defendants prosecuted and the nature and volume of the evidence, which is it's just hilarious to me. It's ridiculous. Over 300 individuals have been charged in connection with the Capitol attack. 300 people. Wow, really? 300 people? So how many people do they prosecute in a year? Typically. I don't know the number to that. But is adding 300 to the entire U.S. Attorney's Office that governs the entire country something that is like groundbreaking? This is the biggest in American history because there's 300 rioters that they're prosecuting. It's dramatic. It might be factually true, right? I don't know if they've ever investigated 300 people that were all related to an incident before, but this is not like multi-levels of financial transactions, drug running. I mean, have they not prosecuted a drug cartel in this country? Have they not gone after, massive gang enterprises that have all sorts of information before? This is it. This is the biggest one. It's 2021. Our country has been running for a long period of time. This is the biggest in American history from the U.S. Department of Justice. Okay, over 300 individuals have been charged in connection with the Capitol attack. The investigation continues. The government expects that at least 100 additional individuals will be charged. While most of the cases have been brought against individual defendants, the government is also investigating conspiratorial activity that occurred prior to January 6. The spectrum of crimes charged and under investigations in connection with the Capitol is limited. It includes, but not limited to, trespass. So, wow, a bunch of trespass cases. Wow, that's just groundbreaking. Engaging in disruptive or violent conduct. Wow, outstanding. Destruction of government property, theft of government property, assaults on federal and local police officers, firearms offenses, civil disorder, obstruction, and on and on and on. Possession and use of destructive devices. Did Jacob Chansley have that? Did he have destructive devices? Was it the spear that they're talking about? Okay, so defendants charged and under investigation come from throughout the United States. 900 search warrants. Wow, my gosh. Wow, for the entire Department of Justice. That's a lot. 50 states, District of Columbia, multiple law enforcement agencies were involved. U.S. Capitol Police, Metro PD, FBI, Department of Homeland Security, Bureau of Alcohol, Tobacco, and Firearms. So we have all of these agencies. U.S. Secret Service, U.S. Capitol Police, Park Police, Virginia State Police, Arlington County Police, Prince William County Police, Maryland Police, Montgomery, and on and on and on. Oh my gosh. More than 15,000 hours of surveillance, 1,600 electronic devices, hundreds of search electronic providers, 210,000 tips, 80,000 reports, 93 attachments. The list goes on. What does any of this have to do with Jacob Chansley? Did they have 15,000 hours of surveillance in Jacob Chansley's case? How about 1,600 electronic devices in his case? How about 210,000 tips in his case? Or 93,000 attachment in his case? No, of course not. So whose problem is this? Not Jacob Chansley's. It's the government's problem. And they also have like 25 different agencies who are involved in this. Tens of thousands of people, it sounds like, probably. How many thousands of people are in the U.S. Department of Justice or in the U.S. Attorney's Office or the FBI for that matter? So they are saying that they have a capacity problem. We have a lot of stuff that we got to do. We got to look through all of this stuff. And therefore, we need a continuance in this case. U.S. is aware and takes seriously its obligations under the rules of criminal procedure. The government, along with the federal public defender, is developing a comprehensive plan for handling, tracking, processing, reviewing, producing discovery across the Capitol attack cases. Under the plan, the discovery most directly and immediately related to pending charges and cases involving detained defendants will be provided within the next 30 to 60 days. Cases that do not involve detained defendants will follow thereafter. So they're saying that if you are in custody, they're going to get you the discovery quickly. If you're out of custody, well, you can wait a little bit because you're not in custody. If you're in custody, they want to move your case along more quickly. But if you're out, they're going to take some more time on it. It says here, cases that do not involve defendants, detained defendants will be released thereafter. Productions will also be supplemented on an ongoing basis. In the longer term, the plan will include a system for storing, organizing, searching, producing, whatever. Nobody cares about any of that. That is your problem, government. That is not Jacob Chansley's problems. Figure your crap out and give him the discovery because he is the person who is in custody. This latter portion of the plan will require more time to develop and implement, in further consultation with the federal public defender. All right. In this case, 2 felonies, obstruction of congressional proceeding, and civil disorder, which he is still in custody for. 4 misdemeanors, unlawful entry into the Capitol building. The government already provided defense counsel with preliminary discovery, including cell phone videos, photographs, evidence collected, and reports of FBI interviews with the defendant. So they've already got it to him, which is great. So what do they need a continuance for? They got preliminary discovery to him. Get him the rest of it. You've got a lot of resources to do that. Here's the argument. Pursuant to the Speedy Trial Act, an indictment charging an individual with the commission of offense must generally be filed within 30 days. Further, in any case in which a plea of not guilty is entered, defendant charged with the commission the indictment must commence within 70 days from the filing date. Section 3161 of the Speedy Trial Act sets forth certain periods of delay which the court must exclude from the computation of time. And so this is what I'm talking about. How do you compute the time? Speedy Trial Act says, well, there are certain things where we can do that. As is relevant for this motion for continuance, the court must exclude any period of delay resulting from a continuance granted by a judge at the request of the attorney if the judge granted such a continuance on the basis of his findings that the ends of justice served by taking such an action outweigh the best interest of the public and the defendant in a speedy trial. So here the government is saying our justice, our version of justice, our need to go create this database and this file and work with the federal public defender and create a bureaucracy to go prosecute all these Capitol Hill rioters, that in the interest of the government, they need to establish that Jacob Chansley's got to sit in custody for another 60 days because the government is incompetent and they haven't figured it out yet. They haven't been able to devise a system where they can process 300 people. It's insane, folks. 300 people is ridiculous. Do you know how many people our firm represents every year? Well above that, okay? And we have like 20 people here. So this is insane. This is ridiculous. And let's go on, see what other garbage is in this motion. This provision further requires the court to set forth its reasons for finding that any ends of justice continuance is warranted. Here are the non-exhaustive factors that the judge should consider. Whether the failure to grant a continuance would be likely to make a continuation of such proceeding impossible or result in a miscarriage of justice. So no, a continuance won't make it impossible. Whether the case is so unusual or complex due to the number of the defendants, the nature of the prosecution, or the existence of novel questions of fact or law that it is unreasonable to expect adequate preparation for pretrial proceedings or the trial within the time limits established by this section. So this is what they're going to hang their hat on, right? Oh, it's so unusual. Oh, it's so complex. Yeah, we had, a few hundred people you're going to charge with crimes in a country of 370 million people? You guys can't figure it out? Whether the failure to grant such a continuance in a case taken as a whole is not so unusual and complex that it would fall within the clause. Here's the argument. Importantly, in setting forth the statutory factors, whether they justify a continuance, Congress twice recognized the importance of adequate pretrial preparation time. Yeah, it's for the defendant. Any interest of justice finding is within the discretion of the court. The substantive balancing of the underlying decision to grant such a continuance is entrusted in our district court's sound discretion. All right, here it is. In this case, an ends of justice warrant continuance is warranted. Why? As described above, the Capitol attack is likely the most complex investigation ever prosecuted by the Department of Justice. Can you believe that? The Capitol attack is the most complex investigation ever prosecuted by the Department of Justice. Well, that leaves me with very little faith in them at all. We have some pretty big criminal organizations in this country, including what they hate, these white supremacists and things like that. All right. This is it. This is the biggest one. None of the drug cartels, none of the child sex trafficking rings, none of the smuggling or other conspiracies that go on that we see on a regular basis. It's this. A couple hundred people were storming around the Capitol building. The most complex in the history of the country. Okay. Developing a system for storing and searching and producing and making available voluminous materials and ensuring the system will be workable will take time. That's your time. That is not the defendant's time. The defense does not have to just hang out in court and just wait around in prison or in custody while you build your system. Even after a system generally agreeable to the government and the federal public defender is designed, likely through the use of outside vendors, so now they're going to bring in some third-party contractors because they can't figure it out, it'll take time to load, process, search, and review discovery materials. Further, adding production and review time, certain sensitive materials may require redaction on dissemination. Other materials may need to be filtered. Again, folks, this is their problem. It is not Jacob Chansley's problem. It is not the defendant's problem. They have to figure this out, not him. The need for reasonable time to organize, produce, and review discovery is among multiple pretrial preparation grounds that the Court of Appeals have routinely held as sufficient to grant continuances and exclude the time. They go through some case law here. 4 new counts, thousands of pages of documents. District Court did not abuse its discretion. U.S. versus Gordon. Documents detailing, let's go through this one. U.S. versus Gordon, upholding ends of justice continuance of 10 months and 24 days in cases involving violation of federal securities laws. So that sounds complicated, where discovery included documents detailing the hundreds of financial transactions that form the basis for the charges and hundreds and thousands of documents that need to be cataloged and separated so the parties could identify the relevant ones. Yeah, financial transactions with hundreds of thousands of documents for a certain set of defendants. This is not the crime of the century. This is not hundreds of thousands of financial transactions. This is for one individual defendant. What the government is doing is they're trying to lump all of these defendants into one bucket and say they need a continuance for all of the cases. That's not how that works. Every single independent defendant has their own individual rights. They don't get lumped into a bucket with everybody else. And they say, well, we're only going to grant speedy trial rights in certain situations and not for the others of you who are in a different category. It's an individual basis. It's Jacob Chansley and Jacob Chansley's case. I don't endorse anything that he did, but this is ridiculous. This is so reprehensible. And you know what? The judge is probably going to grant this stupid thing. It says here, justice, let's look at another one. Upholding 90 days ends of justice continuance in case involving international conspiracy to smuggle protected wildlife into the United States, where the defendant's case was joined with several co-defendants and there were ongoing investigations, voluminous discovery, a large number of counts, and potential witnesses from other countries. Here's another one. Ends of justice continuance. It told it 5 months, 25 days, a wire fraud case that began with 8 charged defendants, ended with a single defendant exercising a right to trial based on the complexity of the case, the magnitude of the discovery, and the attorney's schedules. Those are very complicated cases. Okay, this is a trespass case. This is one person. They have the evidence. Jacob Chansley's basically dead to rights. He's in there taking photographs of himself. His video all over the place. What else do they need to prove their case? They don't need anything else. This is all baloney. They're trying to keep him in custody and extend this for political reasons. They have enough evidence to go and bring a trial against Jacob Chansley and convict him 99 out of 100 times. Probably 999 out of 1,000 times, if not more than that, because the evidence is so damning. They don't want to let him out of custody. They want to hold him in there, and they want to ask for continuances, and then they want to violate his speedy trial rights for political BS. Let's close this out. We see here, in sum, due to the number of individuals currently charged across the Capitol attack and the nature of those charges, the ongoing investigation of many other individuals, the volume and the nature of potentially discoverable of materials, the reasonable time necessary for effective preparation, the failure to grant a continuance would likely make a continuation of this proceeding impossible and resulting miscarriage of justice, which is total BS. Accordingly, the ends of justice served by granting a request, they outweigh the best interest of the public and the defendant. No, they do not. They do not outweigh his defense, his rights. The government asked they grant the motion for a 60-day continuance on the basis that the ends of justice served by taking such actions outweigh the best interest of the public. Signed off on here by Kimberly L. Paschal. What a joke. What a joke of a motion. All right, so another one from Robert Barnes here from Fox says they've charged over 600 people at this point, actually. I don't care if it's 1,000. I don't care if it's 2,000 people. The defendant's rights are the defendant's rights. He's got a right to a speedy trial. A blanket continuance motion is so reprehensible, and I would hope that Jacob Chansley's attorneys would object to this. And I know the judge, because the judge is already in the pocket. We've already seen how biased this person is, that I think he's probably going to grant it, quite frankly. And I think this is something that should be appealed. I think that they should appeal it up, and they should say that this is not acceptable. I would be so outraged if this happened to one of our clients. And so would the judges, and so would the prosecutors, actually. It's embarrassing. We have Sharon Quinney says, this doesn't sound fair at all. It is, as you say, reprehensible. He can't get bail. They want him to stay in jail for a longer time for carrying a spear, so that makes him a danger to society. He seems like your average space case to me. Yeah, it's not the crime of the century. This isn't international drug smuggling. This isn't importing protected wildlife or complex financial transactions where there's hundreds of thousands of bank records and mounds of evidence. This guy walked into a building that he shouldn't have walked into, carrying a spear. That's it. What do you need to prove that case? Apparently, the FBI needs a lot of time to figure this out. So do the U.S. Attorney's Office, because they just can't get it together. For 600 people? If it's 1,000 people, it's the entire Justice Department. It is the entire FBI. We saw the list of other people working on this case. How many tens of thousands of people are on there? God. News Now Wyoming says, here, anyone released from jail without bond due to COVID was also made to waive speedy trial claims. They still haven't done very many criminal trials in Wyoming. These get me hot. Remark number 2 says, are they still angry that they couldn't impeach the president? Yeah, they're still angry. They're gonna milk this. They're gonna just squeeze this thing for every ounce. They don't want these things closed. They want continuances. They're going to make this like just the prosecution of, the Nazis. That's where this is going. And they need, this is so complex. This is the biggest thing that folks, I know prosecutors who would laugh at this, truthfully. Maybe I'll get one on the show to just, because they can't do that, because they can't comment on anything. But this is a joke. That they can't prosecute 600 people. Disclosing discovery is not that big of a deal. Okay, this is not, now look, if there are a few defendants that they need a continuance on, if they say, look, on this one particular case, we need a continuance on Jacob Chansley's case. Why? Well, because he's very complicated. He's the leader of some sort of shaman mob, and he's got this infrastructure where he's got different cells around the country, and we're investigating him in order to find out what those connections are, and we're going to bring this massive co-defendant case. We're going to lump them all into this massive prosecution. We need more time for that, and we can't let him out of custody because he's the ringleader of this massive organization, and we need the material and the time to go investigate it. That's different. They may need that for some other people here, but not Jacob Chansley. The rights are to the individual defendant. The government is trying to lump him into a bucket and then violate everybody's rights, sort of on this a batch system. It's not good. This is problematic. Croc 1 Alpha says, if the DOJ is complaining about the amount of work they have to do, it makes me wonder, all the prosecutions they have done against the cartels, gangs, organized crime in the past, did they just not bring them into custody until they had the legal work prepped already? Let them commit crimes for years and years because they were not ready to bring them in. Sounds like a confession of that to me. Yeah, well, I mean, I guess, are the cartels less than 1,000 people? That they can't keep tabs? Do they have a breaking point? Oh my gosh, we've been really busy. It's like at a restaurant when they get a rush. Oh, we got a rush. We just can't handle this. If the government can't handle it, do you know what their option is? It's to dismiss the charges. They could bring the charges back at a later date. There are statute of limitations. They can voluntarily dismiss them, wait till they bring up the resources, bring them back. It's their obligation to prosecute. Okay. When you're charged with a crime, it's not your obligation to just sit around and say, hey, government, whenever you're ready, go ahead and prosecute me. I'll just sit in custody for the next 60 days. Oh, my speedy trial rights. Yeah, you can waive those. I don't care. Do whatever you want with those because they don't matter. If you need them, if you need more time, go for it. Hack Consulting says, LOL, they are bogged down because they are wading through too much conspiracy and trying to justify true from false. Also, the net is cast too wide with too low of a standard. The best argument for the government is that they were the victim. They should have stopped lying about the flat earth had it coming. Yeah, they could easily prosecute this case with what they have now. They don't need any more time. They might need it for other people, but that doesn't matter to Jacob's case. Who's next? We got Sharon Quidney in the house says, I think all these people in jail over the Capitol Hill riot, they're all surrogates for Trump. And the powers that be are just making a statement with these people's lives, which is horrible. They didn't get their impeachment, so they're going to take it out on the people they rounded up. It's a big witch hunt. Exactly right, Sharon. Good points. Liberty or Death says, people may have a negative view of my law school. I sympathize. But at least I know that the defendant is innocent until proven guilty. Making the shaman stay in jail while they develop their case is nothing short than a violation of the 6th and 8th Amendments. This is just as egregious as the judge's order denying bail. It is offensive to our republic. Hear, liberty or death. That is exactly right. This is something... this is a big bureaucracy saying, oh, everybody's individual rights as a defendant, they have to accommodate our bureaucracy. That's not how that works. Nope, you've got your own individual rights. If the government can't bring a case against you, whose fault is that? It's the government's fault, not Chansley's. They're trying to make it his fault. They're trying to prejudice him as a result of their own failure to have their stuff together. Jeremy says, it's only complex because they need time to make up charges beyond trespassing. Yeah. I mean, this is not the crime of the century. I know everybody's trying to make it out to be that. And you might believe that. You might believe that it was part of a conspiracy or whatever. But the crime here, the law, the legal crime were the trespass, civil disorder, and some other, mostly minor BS. They can prove that easily. It's not a complicated crime. A DUI crime is way more complicated. A single DUI is way more complicated than anything that I've seen from any of these Capitol Hill people. Because you have science and you have gas chromatography and you've got all sorts of absorption phases. It's complex. These are just 300 cases. 300 cases of trespass happen every night in LA. Okay, every night, 300 of them. They can figure it out. They can prosecute those. Let's say let's call it the Old Town crimes. Okay, how many disorderly conducts, urinating in Publix, criminal damages, civil disorders, all of those crimes happen in Old Town Scottsdale, right down the road from my office, every 3 months? How many of them? I'm 300 at least. And their prosecution office that has, 10 lawyers, they figure it out. They can handle it. If they had, instead of 300, if they had 600, they would figure it out because it's not complicated. All right. We have Jeremy Matrita says, couldn't the trespassers use entrapment as a defense? There's plenty of video evidence of officers unlocking the doors and waving people into the building. All right. Waving people into the building. I think that's just I'm part of the tour defense. It's not a bad defense, honestly. I think it's something that I think everybody there ultimately knew. Put it this way. If you were on a jury and somebody walked in and said, no, the officers told me to come in. And they explain that as, well, not really. Well, I'm not sure. Maybe it is a good defense. I don't know. It's worth trying. I think it's probably the only defense that exists. Seawolf74 says prosecutors can't comment. What about Ken Kratz in Making a Murderer? Are there some exceptions? Yeah, I mean, they have to go and get permission from their, from their supervisor and things. They can comment. It's not like there is a prohibition on that. What I meant is, if I'm going to bring a prosecutor on the show to laugh at how embarrassing other prosecutors are, I would never find a prosecutor to do that unless it was somebody who was a former prosecutor or somebody who was retired, because, prosecutors are sort of they're not going to condemn their own people. They're not going to come out here and say, yeah, this is embarrassing and ridiculous, which was really my point. But you're right. They can comment. Will they? No, because they're all going to protect each other. I'm not going to be able to find anybody to come out here and rip on the U.S. Attorney's Office. Big Dog 1111 said, great job yesterday with Viva and Barnes. Thank you. Sharing your life journey takes courage. Much respect for your perspective on your clients' rights and the flaws and bad guys in our system. Keep the great analysis coming. Thank you, Big Dog. Very nice statement from you. I appreciate that. And I love your support. And then our last question of the day comes from News Now Wyoming. Says, I have never heard your story before and was touched hearing it. Thank you. When you have cases similar to your brother's, do you find yourself personalizing them more than you would somebody pulled over for a different type of case? No, I don't really. I actually don't. I don't think that I draw any real distinctions between that. I mean, I'm somebody who I can be really empathetic to people. I can kind of feel what they're feeling, and it doesn't have to be any one particular category. I sort of don't distinguish between alcohol or drugs or sex or, just personal, other personal issues. They're all kind of, when people are hurting, I'm interested in helping them solve that hurt. And so hurt can mean a number of different things. Somebody who died by suicide or who had a struggle with heroin. Yeah, I mean, I understand that because my family went through that, but it's not really that different. So, for example, in my men's group, it's not just a 12-step alcohol program. It's kind of 12 steps for anything. There's a lot of things that afflict people in their lives. It doesn't have to just be one particular substance. It can be food, it can be sex, it can be gambling. There's a lot of hurt in this world. And I really can empathize, I think, with people on that level. And if I can provide value in some form to help them, then I'm going to do that. And it's not like there's a certain category of people who get special, heroin, suicide, overdose privileges. It's all kind of the same. If I can be useful to the world, I want to do my best to do that. And I'm hopeful that me speaking out about my story just a little bit, it is vulnerable for me. It's not something that I'm very comfortable talking about. I don't know if you were able to see that on the show yesterday, but I don't typically like to talk about that stuff because it feels, I don't want people to come away with the conclusion like I consider myself to be a victim or like I'm blaming my brother or my life circumstances for anything in this world. I've really made peace with a lot of it, and I'm grateful for a lot of it because I think I have grown as a human being as a result of those life experiences. And so I wouldn't, I don't wish them on myself. If I could have my brother back, I would trade everything for that. But I can't. And I know that I can use that loss and I can use our family's healing to go do better in the world. And if I can help share my story with just a small impact, maybe it touches somebody, maybe somebody hears that and goes, gosh, I was thinking about that myself. Maybe they reach out, pick up the phone, call a friend, call a counselor, stop drinking for a minute, go check out a 12-step meeting, whatever that looks like. Then I think that I've got an obligation to do that because I know there's a lot of hurt in this world and I'm just trying in my own little way to be a part of a solution, which is why I get so fired up on a lot of these issues. But thank you for the kind words. Thank you for the support. It is a vulnerable thing for me to do, to go on another show and just say, hey, I was an alcoholic. It's not something that is traditionally easy to talk about, but I do it with the hope that it is meaningful to some people out there. And I appreciate you being so kind and receptive of that. And so thank you for the questions and all of the lovely feedback. I had a lot of fun with those guys. I think they're good guys. I want to support them. I want to support other people out there in the world who are doing good things and engaging in good conversations. And I like people who move the needle, who are doing things in a way that I think can lead to meaningful change, whether that is in my political direction or not. I think as long as we're all moving towards the same goals of improving humanity, being of service to our fellow men and women, then we're on the right track. We might not always agree on how to get there, but the people with good intentions, the people who are moving the needle in the right way, I want to support them. And so I appreciate you helping me in that, helping me go over there and subscribe to their channel, join them on Locals, because I think they are good guys. And I'm looking forward to continuing to meet other good people and sort of sharing our journeys and sharing our experiences with one another. And so that is it for me today, everybody. I want to thank you so much for being here. We're going to be back same time, same place tomorrow. However, we got to say thank you to our local subscribers. all of these tremendous people over there on locals.com. Let's see who's in the house. Thank you to Ma Fox. Thank you for Miss Faith Joy. We've got Loxton. We've got Soch. We've got CLRO, Scrutcher. We have Mr. Swift, Feisty Lady in the house. Let's see. We got Jamie Boyd. We have Kula Bula. We have Fish Our Friends, Nadar Blasier. We have Sarah Hagar. We had a lot of people sign up last night. Probably a little love over from the show on Viva and Barnes. We've got Social Viking. Welcome to the crew. We got Be Brave. We have Chuck, 2021, Millennial Mystic. Ooh, that's nice. John Them You. We have Jay Bartell in the house. We got S.J. Warrener. We have M.I. Liberty. We have Joe New. And we have Plate Streaker 9. Got some good people in the house. We're excited to have you a part of our community. If you want to join in on that community, it's over at this address, watchingthewatchers.locals.com. And there's a lot of good stuff you can get over there. Here's just a quick sampling. Free copy of my book, free PDF is available over there. Copy of the slides, as I mentioned at the start of the show, those are going to be posted there as well. All of my existence system documents are there. This is a little personal productivity tool that I have developed, and it's free and available for you if you want to download it. Also made a video on January 1st, 2021 that explains how to use this and how to format this so that you can use it for yourself. Impeachment party documents, we share links throughout the day. The real reason to be there, though, is the great people, all of the tremendous people that you get to know. We're all building a community together, and we're grateful for those of you who have joined us and who are considering it. So watchingthewatchers.locals.com. And that's it for me. Before we get out of here, quick reminder that I am a criminal defense lawyer, as I mentioned, over here at the R&R Law Group. We offer free case evaluations. We handle any criminal cases in the state of Arizona. Our mission is to help good people who have been charged with crimes to find safety, clarity, and hope in their cases and in their futures. And we do a pretty good job of it. We can help people with everything. Things like DUIs, domestic violence, drug offenses, misdemeanor offenses, traffic offenses, major felonies, minor felonies, everything in between. If you need to restore your rights so you can vote, go and get a firearm. If you want to quash an old warrant so that you can sort of get things back on track, you don't have this warrant hanging over your head. If you want to get mugshots removed off of the internet, clean up your record, expunge a case, set aside an old conviction, we can help with all of that. And we have a free case evaluation here in our office. We can do it by phone. We can have you come on in. We have an awesome team of people here. If you come in, we'll give you a copy of my book. We'll make sure that you leave better than when you came in, because we want to help people get things back together. And so if you know anybody who has been in a situation like this, whether they need help or they're thinking about help or they want to just clear some old stuff up, we would be honored and humbled if you sent them our direction. We'll make sure that we treat them with care and the utmost respect. So that's it for me, everybody. We're going to be back here same time, same place tomorrow. We are going to hop on Clubhouse right now. If you want to join in, there is a link. There's a description below. We're going to chat for, I don't know, 30, 45, maybe an hour. Who knows? I always say that I'm not going to spend that much time on there, and then it's like 10:30, and I'm like, oh, it's 10:30. I probably should eat dinner now, but it's a lot of fun. So if you want to join us, the link is in the description below. Same time, same place tomorrow, 4 p.m. Arizona time, 4 p.m. West Coast time, 5 p.m. Mountain, 6 p.m. Central in Texas, 7 p.m. on the East Coast. And for that one Florida man out there, everybody have a very lovely evening. Sleep well. Have a tremendous dinner. I'll see you right back here tomorrow. Bye-bye.